For the Wild podcast is brought to you in part by the Calliopeia Foundation and listeners like you. Calliopeia supports projects interweaving spirituality, culture, and ecology. We are grateful for their support and the support of grassroots contributions from listeners. To learn more about the Calliopeia Foundation, visit calliopeia.org. To make a donation to For the Wild, visit forthewild.world/donate or support us through Patreon.
Hello and welcome to For the Wild. I'm Ayana Young. Today I will be speaking with Lauren Regan. Lauren is the executive director, founder, and senior staff attorney at the Civil Liberties Defense Center.
When we start dealing with water shortages and food shortages and flooding and sea level rise, and all these different consequences, as that starts to affect people more and more in their daily lives, I think that we will see the lines in this battle more clearly drawn, and more people, I believe, will be joining the climate movement in order to try and preserve some semblance of civilization for future generations.
Lauren has extensive federal and state litigation experience in both civil rights and activist defense cases, as well as expertise in necessity and other constitutional defenses. She has a Juris Doctorate in law, bachelor degrees in political science and psychology, and is a national expert in the defense of political activists, particularly those engaged in climate justice, environmental animal rights, indigenous and anti-capitalist movements and their intersections. Lauren and the CLDC provides more than 50 Know Your Right trainings each year to activists, immigrants, indigenous communities, rural landowners resisting pipelines, and many other at-risk groups. Lauren is also an Oregon State Bar Leadership Fellow, a volunteer teen court judge, and has been given dozens of public interest attorney awards, and has been interviewed in dozens of publications and documentary films over her 22 years of activist lawyering. Well, Lauren, thank you so much for joining me today. I am extremely grateful for the work you have put in over your 22-year career, and we are just so blessed to be speaking with you. So thanks for being on For the Wild podcast.
Yeah, thanks. Yeah, whenever I hear that number, I have to actually still do the math in my head, because I think to myself, how could I be a lawyer for 22 years when I'm barely 22 myself? But then I actually do the math and realize it has been that long.
Oh, well, thank goodness it has.
But it doesn't feel that long. So
Yeah. Well, thank goodness we've had you doing this work for that long, because I know there's so much struggle out there. Now, Lauren, back in September of 2019, the Washington Supreme Court set a state precedent in recognizing the necessity defense for climate-related direct action with regards to Ken Ward's Valve Turner trial in Washington. Now, just to clarify for listeners who may be unfamiliar, the Valve Turners closed the valves on 5 pipelines back in October of 2016, effectively shutting down 15% of U.S. crude oil imports for a day. So I'd like to talk about the potential of the necessity defense, and what does its recognition say about how communities are orienting themselves to climate change?
yeah, so we have been trying to use the choice of evils defense, or sometimes it's called the necessity defense or the justification defense. Each state kind of has a different name depending on the statute. We've been trying to use that defense in the climate context for about a decade. And the way that the process works is when someone is arrested and charged with a misdemeanor or felony, the defendant has to provide the court with notice that they intend to use this necessity defense. So we file a 1-page document that says we're going to use the necessity defense. And normally what happens next is that the prosecutor will try to ask the court to exclude that defense so that we can't talk about it or put on experts in testimony during the trial. And so normally what would happen is the prosecution files what's called a motion in limine, which just is Latin for a motion to exclude evidence. And in response to that motion, we normally will file a big giant brief that talks about why the defense is justified, what the evidence is, what we intend to put on in terms of witness statements. We load them up with like everything Dr. Hansen has ever, written in his career, and we file it all with the court, and we say we should be able to put on this defense because we've got enough evidence to substantiate it. And more often than not in the past, the judges have ruled against us, and they have said that we don't get to talk about the necessity of climate action. And the number one reason that they have usually given is that they claim that the climate crisis was not imminent enough because, back then scientists were saying, maybe we have 50 years, maybe we have 20 years. It was not as concrete as it is today. And then the other defense that they would say is that we can't prove that this person, this defendant, was actually threatened with harm, because even if we believe what you're telling us about climate change, it's going to happen to island nations and places far away, and it's not going to happen in Skagit County, Washington, for instance. And so that went on for a while until actually we had another valve turner case filed in Minnesota. So as you mentioned, the valve turners were in 4 different locations. They were in Washington, Montana, Minnesota, and North Dakota. And so the Minnesota valve turners, we filed the necessity briefing. And in that case, the trial court judge said, yeah, they passed the test. They should be able to use this defense at trial. And that was the first time that we had a district court judge actually open up the gates and let us in. And in that case, the prosecutor, the state of Minnesota, appealed the court's decision to let us use the defense. So in that case, it went up to the Minnesota Court of Appeals, and the Minnesota Court of Appeals ruled in our favor and said, yeah, these activists should be able to put on the defense. And then the state of Minnesota appealed up to the Minnesota Supreme Court, and the Minnesota Supreme Court affirmed the lower court. And so the first state to basically create precedent throughout the entire state was Minnesota, to say that climate activists who can pass the test should be able to use the defense. And of course, Minnesota, a super important state with regard to Line 3 and a lot of fossil fuel infrastructure development that is being shoved down the throats of both indigenous communities and other communities. And so this was a really important precedent. So once the Supreme Court ruled in our favor, we put experts together. We had Dr. James Hansen, we had medical doctors, we had policy analysts, we had experts in the efficacy of nonviolent civil disobedience, all lined up to testify along with our clients. Everybody was like waiting in a room to be brought out to testify. And in that trial, the prosecution goes first. They put on their case. And then once the prosecution closes, then the defendant's lawyers will normally do what's called motion for judgment of acquittal, which just basically says, hey, judge, the prosecution didn't meet their burden of proof, and you should throw out all these charges. And in Minnesota, the defendants were facing multiple felonies. They were facing like 30 years in prison. And some of the felony charges were these new critical energy infrastructure felonies for messing with pipelines. And so we put on an argument that we never expected to win, saying the state didn't prove that these activists actually damaged the pipeline. And so, judge, you should dismiss all of these charges. And the next thing that happened is the judge picked up a piece of paper from the bench, something that was written that he had prepared, apparently, and he began to read from this piece of paper, and he granted our motion for judgment of acquittal which on the one hand means that our clients were found not guilty of all of these felonies, including critical energy infrastructure. That's a huge victory. But on the other hand, the judge, by granting that motion, shut down our entire case, and we were foreclosed from actually putting on the necessity defense that we had long prepared and dreamed of doing. So victory, but not for the necessity defense. And so as that case was winding through, Ken Ward's case in Skagit County was also winding its way through the process. And in a similar process in Washington, we appealed the court's denial of the necessity defense up to the Washington Court of Appeals. And as you mentioned, the Court of Appeals ended up ruling in our favor in a very strongly worded opinion where the court says climate change is here, it's now, the harms are serious, like all of the criteria for this defense are met by, what the defendants intend to put forward as evidence and testimony. So in that case, also the state appealed up to the Washington Supreme Court, and the Washington Supreme Court affirmed the lower court's ruling. The reason that it's significant that the state appealed all the way to the Supreme Court is when that happens, the state itself creates precedent that has to be followed across the state. If they had not appealed the lower court's ruling, then that ruling only would have applied to the county where the court case was going on. But because it went all the way up to the Supreme Court in each of those states, that ruling is now binding on every court in the state. And because it went up to the Supreme Court level, now we can use those state Supreme Court decisions to say, hey, North Dakota, hey, Montana, you should rule like these other cases in these other states because the facts are identical or the facts are similar. So that's been going on. And then, to be frank, in the meantime, we recently just had a case here in Oregon with Extinction Rebellion activists in Portland, Oregon, that shut down oil trains and shut down a tar sands oil and gas facility called Zenith Energy. And in that case, the state decided to take the tactic of not challenging us on the use of the necessity defense. And so at the trial court level, there was no objection by the prosecutor. And just a couple of weeks ago, we went through a full jury trial of being able to put on the necessity defense. We had climate experts, we had policy and law experts, we had an academic that testified about the efficacy of direct action, and we were able to present all of that to a jury. And at the end of the jury trial, the judge actually was able to provide them with a jury instruction and literally said, jurors, you are now allowed to utilize this choice of evils necessity defense if you find that the harms of climate change are worse than the harms of committing trespass on corporate property. Then you can acquit these defendants of the charge of criminal trespass. And in that case, 5 out of 6 of the jurors voted to find the defendants not guilty as a result of the necessity defense. One juror held out and said that they didn't think that the defense applied. So that resulted in a hung jury. When a hung jury happens, then the state basically has to decide whether they want to re-prosecute and go through trial all over again. And just yesterday, the state of Oregon made the decision that they were unable to proceed and that they did not want a new trial. And so all of the charges were dismissed against the activists. And I think that that is the first of its kind in the US. The first time that all evidence and jury instructions for climate necessity defense have been allowed in a court proceeding.
Wow, Lauren, thank you so much for taking us through all of those details. And I'm sure there's so many more, but that was a huge educational learning for me. So thank you for sharing that. Now, before we delve deeper into topics of activist defense and the law, I'm hoping we can highlight the long-standing connections between private companies, a booming pipeline industry, and the increase in corporate-friendly punitive legislation. For example, the American Legislative Exchange Council, that's a mouthful, or ALEC, is responsible for the drafting of anti-protest legislation across the country. Similarly, it was recently revealed that members of the federal government have been meeting with lawyers for various oil companies who are being sued by cities in an attempt to hold them accountable for a changing climate. So while there is a long history of private lobbyists buying elected officials to further industry's agenda, I'm wondering if you can speak to this grave overreach when it comes to groups like ALEC and the shaping of current and future legislation.
Sure. The collusion between corporations and industry and our elected legislators is nothing new. ALEC has been going on since the 80s. And, to be frank, ALEC got so much bad rep over the last 10 years that a lot of the anti-protest legislation, these critical energy infrastructure laws, are actually not overtly being pushed around by ALEC, but by different front groups and industry groups and Koch brother type think tanks and and other kind of more nefarious, more ambiguous entities. That is unfortunately nothing new. And in fact, in our recent trial, the policy and law expert that we had on the stand basically testified that the fossil fuel industry is spending over $30 billion on media and advocacy campaigns to try and sustain its industry and to try to confuse and manipulate the general public into thinking that they're the good guys and that climate activists are the bad guys. And one of the big things that he talked about was how the fossil fuel industry is subverting our democracy, especially at the local level. And they're doing that by, saying to your state or local representatives, if you push our legislation through, we will give you a bunch of money for your campaign. Or if you fight against this regulation that will impact our profits, we will give you a bunch of campaign contributions. And unfortunately, we are living in such corrupt times that by and large, legislators, many of them are taking that bait and taking that money. Then you also have court decisions like Citizen United and its prodigy that are basically guaranteeing corporations the constitutional rights that belong to individuals. So there's all of these parts that are going on, whether it is criminalizing dissent, whether it is undoing regulations. I think the Trump administration is also a really classic example of the revolving door between corporations and very high level government officials. For instance, we saw at the EPA, Trump putting in an oil executive to the highest cabinet level position of an agency that used to regulate their corporation, and they used to be enemies. Now they literally put the fox in charge of the hen house for some amount of time period. Then that cabinet level government official eventually leaves public service and goes back into the corporate realm with all of the ties, power, connections that they accumulated while they were acting as a public official. That revolving door of corporations working in government and then leaving government and working for the corporations is another really serious attack at our democratic principles and something that we are going to be having to fight to repair for the next decade or more once the Trump regime is run out of the White House.
Well, hopefully that happens this year.
Yes, we can all cross our fingers and toes.
Yeah, exactly.
What I usually tell activists is that type of repression, state repression, is nothing new. And activism has continued to grow and thrive in spite of it. And a big part of that is because for a lot of activists, when they are engaging in a campaign against a big industry, against a big corporation, they know that they are risking their liberty in doing that. They know that they might get arrested. They know they might get prosecuted and convicted, but they're doing it anyway because of the greater good. And so regardless of what kind of name a crime is given, like these critical energy infrastructure laws are a classic example. They created a new felony when there were already half a dozen felonies that could have applied. Somebody that's going to go in and shut down a pipeline already knows that they may go to jail for felonies as a result of doing that act, but they have made the decision to do it anyway. And so whether they call it felony burglary, felony sabotage, or felony critical energy infrastructure is not going to make or break that person's decision-making process on whether they're going to engage in direct action or not. The same with like corporate spying and, and all these other things that are going on. For activists, they know that they're up against the state. And when I use the word the state, that means both government and the corporate state, because they are working so closely together against the people. So, we know exactly where the lines are drawn, and we know what side we're on versus what side they're on. And now it's just a matter of building that mass movement of people who actually want clean water and want a livable planet versus those that are hell-bent on putting billions of dollars of profits into a few people's bank accounts. Those lines are going to become more and more clear as the dire consequences of climate change are in people's face more and more. When we start dealing with water shortages and food shortages and flooding and sea level rise, and all these different consequences, as that starts to affect people more and more in their daily lives, I think that we will see the lines in this battle more clearly drawn, and more people, I believe, will be joining the climate movement in order to try and preserve some semblance of civilization for future generations.
In one way, I'm excited for that moment, that more people stand up and join the frontline fighters. And then there's also that knowing that for more and more people to join, that will mean that things have gotten even worse. And so it's a mixed bag of emotions when I think about that. But thank you for speaking to all of those themes.
Also, in acknowledging those realities, we should also acknowledge that lower income people, communities of color, like there's going to be disparate impacts on people who are already challenged based on circumstances. So it's not necessarily a fair fight either.
Exactly. Thank you for saying that. Yeah, we see that over and over and over again in so many ways, and we speak to that a lot on this podcast. So that's an important note to take in. In preparing for this interview, I came across a story from The Intercept that highlighted the questionable relationships that are forming in areas where energy infrastructure is set to be constructed. For example, in preparation for the Jordan Cove Energy Project in Coos Bay, Oregon, the parent company, Pembina, has poured money into the unit of the Coos County Sheriff's Office that would be responsible for security concerns related to the project. This, of course, is just one of the many examples where the line between public safety and private security becomes incredibly murky. So I'm wondering if you'd be willing to discuss the current increase of gray intelligence and what this means for environmental activism.
Sure. Yeah. I mean, in the LNG circumstance that you mentioned, which I'm here in Oregon, and we've been fighting off this pipeline for over 15 years. So this is a fight that's been going on a long time. A new corporation, Pembina, came in and is really trying to railroad and ram the project through. And one of the unprecedented things that has occurred is that a fossil fuel corporation has purchased public law enforcement officers to guard and protect their private corporate property. We did extensive research around the country trying to figure out whether this had ever happened before. And the only other example that we could find of a private corporation literally purchasing public law enforcement was in California with regard to a Google campus, I believe. One of these IT tech campuses basically hired public law enforcement officers to specifically patrol their private campus, a large, sprawling campus. That is the only other example in the history of the US that we could find where this has happened. Now, when we started stirring the pot and making some noise about potentially mounting a legal challenge to the idea that our public tax dollars are going to go to buy cops to guard private property, now it appears that they are withdrawing that plan somewhat. It's unclear whether they are suspending that plan or if they actually are going back to the drawing board with it. But yeah, there are so many problems with the idea that a corporation will be able to have local cops doing their bidding. I mean, it's against the basic constitutional rights, civil rights, human rights. There's all sorts of incredible problems with it. But in some ways, it is appealing in its transparency, because we know that this arrangement happens all the time on the sly without there being transparency around it. We know that big corporations, fossil fuel industry facilities make arrangements with cops to do their bidding. Sometimes, like I remember when I was working down in Texas, when the tar sands blockaders were fighting off Keystone XL, there were like TransCanada representatives on site that when cops were macing and gassing lawful protesters, one of the TransCanada individuals kind of walked up to the cops afterward, thanked them, shook their hands, and then basically made some comment about replenishing their pepper spray back at the station. We know that this is nothing new, but it certainly is bold that they are so publicly and openly saying, we can do this now. And I think that really speaks to sort of the times that we are in at the moment, especially with regard to the Trump regime opening the floodgates to these types of fossil fuel projects and profiteering. So we'll see what happens here in Oregon. But what we also know is in the run up to this project, when Pembina took over, we have seen through Freedom of Information Act requests that both the government and private corporations are spying on local activists that are not doing anything illegal. They're holding meetings, they're doing public advocacy, everything that is constitutionally protected. And so probably this summer, the Civil Liberties Defense Center is going to be filing a big, what we're kind of calling COINTELPRO second gen. And what we mean by that is during the 60s and 70s, there was a round of litigation where the government was sued for violating the constitutional rights of activists in illegally spying on them. And the courts ruled that that was a violation of their constitutional rights. And they said, thou shalt not do that anymore. And even though the courts ruled that that was illegal and unconstitutional, we know that those programs of spying on activists never actually ended. They just sort of were driven underground. And now the modern version of that is the government working with corporations, where the corporations are not even bound by the very basic rules that like the FBI are bound to. And so what we see is the private spies doing all sorts of illegal things and things that the FBI would not be able to do. And then the private spies are turning over these investigative materials to the FBI, and then the FBI is utilizing the benefits of those ill-gotten goods, illegally obtained surveillance information. And so we're going to basically sue both private spy agencies and the government for this collusion and say, this is still illegal. It's still unconstitutional. And just because you've made this arrangement with these private spies to do the dirty work doesn't mean that it's any less illegal. And we will basically be asking the federal courts to draw the line again and to basically tell the government that they can't be sharing information with illegal private spies as they are monitoring and conducting surveillance on lawful advocacy. And the importance of this is if we don't have separation between the state and public activism, we are not allowed to effectively advocate against the state. If Big Brother is literally always watching and learning what you are going to do in the future and why, it gives them so much power to be able to shut down that advocacy, either by jailing the leaders of the movement or shutting down the road before the rally gets there. There's all different ways that the state can use that power to basically shut down all of the constitutional rights that we have to advocate against the state and its power structures. You can look around the world and see where those protections don't exist. You see leaders, lawyers, activists being jailed and imprisoned or even murdered for their advocacy against Chevron and all sorts of other things. So, I think it becomes a very important issue of where do we really stand in the United States with regard to these freedoms. And I think that the state has been really effective, especially with the advent of social media, where there is a younger generation that has grown up without really knowing or understanding why the right to privacy is so essential in a democracy. When you have students that have walked through metal detectors since kindergarten and who have basically given up all of their private information to Facebook or WhatsApp or Instagram, they no longer really have a lot of understanding about why there really needs to be this separation between the state and citizenry with regard to privacy and the Fourth Amendment and your First Amendment rights. So they've kind of really raised a generation of people who are much less concerned about these privacy rights. They've basically grown themselves a generation of sheep that don't have as much awareness as maybe past generations have had with regard to that separation.
Mm-hmm. Well, Lauren, in continuing with the theme of gray areas, in response to 9/11, George W. Bush signed the 9/11 Commission Act, which allocated hundreds of millions of dollars to the creation of fusion centers. Currently, there are over 70 of these centers across the country. So I'm wondering if you could speak to the designated purpose of these centers, the frequency in which they're being used, and what kind of actions are they actually monitoring?
Sure. I will premise my remarks in saying that, fusion centers and calling them fusion centers is sort of another propagandist tactic of the state to make people afraid to be advocates and activists. And so, again, I would premise it by saying, like, this is really nothing new in terms of the war on dissent and activism, and should not be viewed as something scary to make you stop hitting the streets or campaigning for a cause. But basically, what they do is funnel a ton of our taxpayer dollars to law enforcement, even more money going to law enforcement than currently exists. And for them to be able to have distinct streams of money being funneled away from social services and into law enforcement. And fusion centers, what their intention was to allow state and local law enforcement to work more closely with federal law enforcement in order to prevent terrorism. That was like the stated intent of them back during the George Bush era. Now, there is no definition of terrorism in the federal and state laws. Generally speaking, there's thousands of different definitions. Generally speaking, the government tends to define terrorism as anybody that they don't like, but it has consistently included anti-capitalists, which often include climate activists, environmental activists, animal rights activists, indigenous activists. They are almost all able to be categorized as anti-capitalist. And that category has consistently been on the dartboard of these fusion centers. So how they practically relate is they will utilize state and local law enforcement intelligence, whether that is infiltrators or overtly uniformed law enforcement, to try and burrow themselves into local activist scenes, campaigns, et cetera, organizations. And then they funnel that intelligence back to these fusion centers, which are then shared around the country through mostly computer networks, databases. So individual organizers, campaign leaders, people who are arrested are often included in these databases. So, if there is like a particularly effective indigenous campaigner in northern Washington who then ends up in Texas and then maybe ends up in Minnesota, these types of databases will provide local law enforcement with that person's photo, name, background information, arrests, et cetera, which then allows local law enforcement to target that person when they, end up in Minnesota, for instance. So, in a lot of ways, we all assume that the state is monitoring us and is sharing it. So I don't necessarily think that this is anything new or anything that people need to be particularly concerned about. As activists, obviously from a democratic standpoint, as a taxpayer, for all other reasons, this is like a complete waste of time and resources, and really sort of demonstrates the unfair disparities of the sides. When the state is able to have that much power and infrastructure to literally be able to monitor frontline community organizers in every nook and cranny in the US, that is certainly a lot of surveillance power. But with that power, their weakness, this behemoth's weakness is that we, the people, are nimble and many, and that giant state fusion center is never going to be able to fully understand and control the way that grassroots activism as a non-hierarchical movement is going to work and adapt and change and build power for itself. So on the one hand, it's horrible, it sucks, it's ridiculous. And on the other hand, it really goes to show how little the federal government and these big corporations really actually understand grassroots movements.
Yeah, I think it's really important and interesting for us to understand things like fusion centers and what's going on. Not that it's totally behind the scenes, but isn't necessarily in many of our day-to-day lives to be thinking or researching things like this. So I appreciate your understanding of it and also explaining to us that just because these exist, they're nothing new. Don't stop being an activist because of this, because we are powerful and there are so many ways in which that we can be creative and ways that, the computer systems will never be able to fully understand or predict or stop us. So I really appreciate the way that you explain that response. And there's literally so much I could ask you about the surveillance state, and the list goes on. And I know we only have an hour, so I'm really deciding which things to not ask you in terms of facial recognition technology and all that jazz. But there's so much for us to talk about. So I'm going to move away from the surveillance state as much as I don't want to at the moment.
Well, let me just add two things like that are proactive on that before we change topics. One is, we strongly encourage people to use the Freedom of Information Act and to FOIA their own files, their organization's files, and just let the government know that, there is some ability for we the people to have some transparency with regard to the dossiers that they're compiling on all of us. And then the second thing I will say about that is, as a result of all the FOIAs that we've done for activists and organizations, it's almost comedic how wrong they are so often. They just get it so wrong because they are so used to thinking in terms of like hierarchical government or corporate structures that they just, especially when they are monitoring indigenous organizers, they'll be, we don't know how these two people know each other and work together. Well, they're tribal members together, idiots, but they just are just off the mark so often that's the other thing that I would just sort of say, like, yeah, they're surveilling us, they're putting together dossiers, but it's awesome how often they are just getting it completely wrong to our benefit. And then if we're not going to talk about facial recognition, one thing I will say about that is what we learned during Standing Rock is that the state didn't really have to go to too much effort to spy on water protectors because so many people were live streaming and putting video and photos up on FaceCrack, what we call FaceCrack, Facebook. And state agents, law enforcement agents, private spies just literally got paid all day and night to monitor people's Facebook pages and live feeds. And because of the facial recognition software in Facebook, they were able to identify anyone and everyone in videos and photos. And I remember one day in particular, we were in a convoy out at Standing Rock to go out to the pipeline route. And the cops stopped the whole convoy, and a bunch of cops started walking along the cars with something the size of a laptop, and they were shining it into each of the cars. And every once in a while, they would stop, open up somebody's car door, and pull out a water protector and arrest them right there on the spot. And what they were doing is they were using live facial recognition to match up facial recognition from a video that they had found online of somebody graffitiing equipment or, whatever they were doing. And they were in real time matching those two faces up and arresting people and prosecuting them as a result of basically shit that we gave them over publicly available social media. So people really, really need to take themselves more seriously when it comes to using social media and the facial recognition components of it. We do a whole separate training on digital security for activists. And I would strongly recommend that people really learn how to make themselves more safe. You can't make yourself entirely safe, but there are ways to make it harder for the state to be able to mess with us. And we should be doing that. We should make it as hard as possible on them to be able to spy on us and to be able to take us down. Because, the reality is when it comes to social media and facial recognition, we're only as strong as our weakest link. If one person is posting video on Facebook, we are all exposed, as a result of that single posting. So as a movement, we really do need to understand the risks and how to basically make our movement stronger and safer in this current time frame.
Well, Lauren, thanks for
Now I'm ready for you to move on.
Yeah. And gosh, yeah, there's so much there. But I do want to talk a little bit more about social media. It was something I was going to ask you about. And I think for many, the belief still holds that visibility is unwanted in environmental activism. But I guess I'm wondering if this is changing as a threat of climate change because climate change is becoming more obvious to so many other people at this point. If perhaps we're entering into a time where there's actually a tremendous amount of public support and thus safety to be found in taking actions that are highly visible and demonstrate the power of our First Amendment rights.
Yeah, I think that Extinction Rebellion Portland case that I mentioned at the beginning is a pretty classic example of, I think, what you're talking about. Two of the women who were defendants in that case, one was a public school teacher for 30 years, and the other worked as a labor organizer for 40 years. They were both retired, children, grandchildren, and they were not what you would normally think of as people who were willing to risk arrest for activism. But their testimonies on the stand was that after they had tried every legal alternative that they could think of to try and protect their communities, their children and grandchildren, the planet from exacerbation of carbon emissions and climate change, they realized that all of those efforts were futile, and the only thing left was to use their body to disrupt the economics of the fossil fuel industry. And so they sat down on train tracks and got arrested. And ultimately, luckily, we won that case. But their testimony basically was like, it's coming to a point where we won't have much more to lose. And when you are thinking about your legacy and how you want to be able to communicate to your children and grandchildren, you want to be able to look them in the eye and say, I tried. And for a lot of ethical people in the world that are paying attention, those days are drawing near, where more and more people are going to have nothing left to lose than to risk arrest in basically putting their bodies between the machines and their communities in order to try and stop the insanity of expanding fossil fuel infrastructure, or even, in the continuation of the fossil fuel industry, especially with regard to like tar sands and coal. It's just insanity that we would be continuing to build new pipelines and new facilities to increase that kind of production right now in the world. And the only reason that that is even viable is because of the billionaires that are pulling the puppet strings and putting that money into their bank accounts and then using that money and power to basically immunize themselves and their industry from what would normally be the checks and balances of democratic accountability.
Gosh, there's so much there, Lauren. But just to clarify around the social media part, because I feel like a lot of folks will be questioning this. So in a way, we don't want to be using social media, Facebook, to make things easier for the state. But at the same time, do you not think that there is any type of safety in being more visible so that the public and the public supporters are more aware of people who may go missing or who may go into prison. But I guess what I'm thinking is if more and more people know through social media what's going on and what activists are the leaders, will they not realize when those leaders are under threat because of social media, because of the decentralization of that form of media?
Well, I mean, I think if you look back at history, some of the strongest, tightest affinity groups and organizing structures were those that were bound together face to face and voice to voice. The more that network expands farther distances, more individuals, the harder it is to hold tightly to the level of trust and accountability that those smaller structures have. You know, the labor movement, for instance, has never stopped going door to door and meeting members face to face because just those brief interactions instill loyalty and shared purpose. And that is protection, especially somebody in New York knowing what I look like is not going to stop Nazis here in Oregon from trying to take me out. But having a group of 50 people in my community that know me, love me, care about me are going to make sure that I stay safe in a different way. And there's, of course, different scales to it. But I think if you look historically at grassroots movement building, you are not necessarily thinking about what is the biggest, flashiest, most. You're thinking about how can I build power and accountability and respect in a community that may be asked more and more to engage in more militant action. You know, I jokingly tell youth that we train, you know, if you would make a flyer and put it up on a light post, it's probably going to be okay for face crack too. You know, if it's something that is not going to potentially harm someone, have at it. It's too bad that we've become so reliant on social media that some people even consider it their activism, but have at it. Where it crosses the line is when you're using people's names, you're using photos, images that not everyone is consenting to disclose to the state. Because I think the bottom line is, you know, when you're posting something on FaceCrack or Instagram, you should basically assume that it is going into an FBI database. It may not be harmful to you, but can it be used by the government to psychologically profile a movement? Can it be used for them to figure out how you pick targets, et cetera, et cetera? So there's just a lot of factors that should be considered when utilizing that technology.
Now, as we come to a close, I'd like to end on a question on the future of climate activism in recognition of the booming oil and gas pipeline business. Although right now that seems to be going the other direction because of coronavirus, but we all know that activism can take a plethora of forms. But we must be honest and realistic in what we can contribute, where our strengths, vulnerabilities, and capacities lie. That being said, it appears that illegal actions are becoming our last hope for real change. Whether it's in raising awareness or setting precedent through the legal system, I also think if more people were physically putting themselves on the line, then it would overflow the systems, the courts, the jails, etc. So there is indeed power in numbers when it comes to direct action. So as somebody who has defended thousands of activists, I'm wondering if you could speak to when and where you think it is appropriate for people to get involved and how we can assess our capabilities realistically.
Well, so the first thing that I would say is people should not be thinking about this as a dichotomy between I'm either going to engage in direct action and risk arrest, or I'm going to do something else. Because for the climate necessity defense, part of the defense is that you need to be able to testify that you are either utilizing now or have attempted all reasonable, lawful alternatives. And what we hear from a number of our activist clients that have successfully used the defense, what they say is we still engage in petition gathering, going to city council meetings, doing all these lawful means. We think that those are important, but they are just not going to win the day on their own. Combined with economic disruption or direct action or nonviolent civil disobedience, whatever term you want to use, when those tactics are combined with all of those other lawful tactics, that is how the movement pushes forward, I believe. And in those circumstances, when an activist can say that, can testify to that, then you've got a real possibility that even in the legal system, a jury of your peers is told to balance the harms. And if you've picked the appropriate tactic and you've done the organizing work that you should be doing anyway, it's likely that in the community where, the jurors are picked, that they are going to hear your testimony, hear the testimony of your experts, and more often than not, the majority of those jurors are going to rule in your favor. And that is because jurors are supposed to be the conscience of your community. And so if you are engaging in a direct action on a pipeline, your community lives with that pipeline. And if you're saying, I did this action because I care about my community, I was trying to keep it safer, I care about the future of the planet, and everything about this project goes against all of those things, people of normal intelligence are going to listen to that. They're going to look you in the eye. They're going to trust you over some out of state or international corporation that on the stand will say, legally, our number one goal is to make as much profit as possible. That is our legal requirement, is to make as much profit as possible. When those distinctions are made really evident in a small courtroom, it is my belief that if we are allowed to utilize this defense and if activists have ensured that they have lined up the defense properly, we will more and more see acquittals by jurors for climate activists engaged in that way. It's important that they maintain good, nonviolent discipline. The jurors in that case I mentioned, one of the things that they said was really important in finding the clients not guilty was that they were polite to the workers and polite to the cops. That was a thing for them, that they really stuck with a pretty strict nonviolence code, even though they were engaging in economic disruption and resistance.
Thank you, Lauren. Now, maybe this could be the last question. This feels relevant, especially with what's going on right now with this global pandemic, disaster recovery. Now, Tiger Swan, which is the private security company notorious for their violent actions and attempted suppression of the No DAPL movement, are positioning themselves to meddle in areas affected by natural disasters. In the past couple of years, Tiger Swan has responded in the aftermath of Hurricane Harvey, Maria, and Matthew. So as someone who is familiar with Tiger Swan and the way they operate, I'm wondering if you could speak to the potential threats if security companies that operate on behalf of industry start intervening in disaster recovery. What agenda will they further? And I do feel like, this is a potentially very relevant question for what we're dealing with right now.
Yeah. When private spy agencies like Tiger Swan are profiting off of disasters, it is a serious problem. That type of disaster assistance should never be privatized. That is the duty of our government. That is what our tax dollars are supposed to go toward. And the idea of outsourcing that to private corporations whose number one goal, like I just mentioned, by law, is to maximize profits, that should never, ever, ever be paired with something like disaster relief or enforcement. And Tiger Swan in particular, the founders of Tiger Swan are all ex-military intelligence people from Middle East theaters. And we have a law in the US, called the Posse Comitatus, which basically says the military shall not police civilian populations. Tiger Swan is an example of basically a military front group. The US knows that they can't put people in US military uniforms and have them using attack dogs on Native American water protectors. That would never hold water. That would never stand up to the laws. But they think by taking those same soldiers and putting them in different uniforms and putting them on a private corporate payroll to do those exact things is somehow legitimate or justified, I think is an incredibly grave, slippery slope. And whether it is prisons or family detention centers or disaster relief, the idea that a corporation would profit off of that kind of suffering, harm, misery is unethical and extremely problematic.
Mm-hmm. Absolutely. Well, Lauren, this information that you shared with us today and also all of the trainings that you do, I feel like are just extremely necessary and so needed right now. I'm so grateful to your knowledge and your passion and your devotion to this work. It's just huge. And I feel like so many of us don't think about this kind of stuff until it's potentially too late or we're already in trouble. And I think about how corporations really, they have enough disposable income to essentially bankrupt individuals once they get in trouble with the law for activist issues. Like I'm thinking about some of the GMO Monsanto cases where they'll just bankrupt farmers. And so I think that we really need to be aware. We need to be aware of these things. We need to understand how to keep ourselves safe as much as possible while also standing up for justice, for climate justice, environmental justice, social justice. We all need a livable planet in order to survive as humans. So this activism is, I think, extremely necessary, but also understanding the ways in which we could potentially be harmed is also necessary. We have to be smarter. We have to really understand the other side because we could be bankrupt, we could go to jail, who knows? I mean, there's so many things, but those types of fear tactics that the state uses shouldn't stop us because what's the alternative? Do nothing and then be completely destroyed by climate change? I don't think the alternative is to do nothing.
Right.
But it's very complex. And
I think the goal of the CLDC is like the idea that knowledge is power. We want to build a stronger, more effective movement, but we also want people to know what they're getting into before they get into it. For instance, with the issue you raised about bankruptcy, one of the things that we talk about in our Know Your Rights training is if you're going up against a litigious industry, talk with a financial consultant and see what you can do to armor any assets that you have before you engage in anything. Because you can't move assets once you're under threat of litigation. But there are lots of things that rich people do all the time to make their money impenetrable. And, it only takes a couple $100 to walk into an office and learn what it is that you can do to make it a little harder. And that peace of mind will empower and embolden you to be able to take braver, maybe more tactically effective actions. So I would definitely say we do Know Your Rights for climate activists as webinars, as well as in person. I really strongly encourage people to make sure that they've got up-to-date information. Part of that training is also teaching activists how the state and corporations spy on you. what they're looking for, what the goods are that they're trying to get on you, so that you could at least try to protect those things. And then the other thing is, we are currently hiring more lawyers because we really believe that the movement needs access to free legal support. And that's what we've defended over 4,500 activists for free around the country. And there's not very many of us here at the CLDC. So we're trying to find like-minded activist lawyers that are willing to come kind of join us on the front lines, and to be able to plant those people in South Dakota, in Minnesota, in the frontline communities that really need that kind of legal support right now.
Mm. Well, I hope the lawyers in the audience hear that call out, or the folks who are studying to be lawyers hear that call out, because we need you. We need you at the CLDC. Gosh, Lauren, I really could have spoken to you all day about these issues. You're so knowledgeable and clear with your analysis. And this is fascinating at one hand, and also it just feels like mandatory information. And you have just done so much work. It's incredible to hear your responses and the depth of your knowledge. So thank you for coming on today. I know you're very busy, and we're very grateful that you've shared this time and space with us.
Well, thanks so much for having me. And, down the road, if you want to pick a particular topic, I would be happy to come back on for some more in-depth.
Okay. Well, now you really got my head turning. Will do, Lauren.
All right. Well, thank you so much.
Yeah. Have a good one. Bye, Lauren.
Bye.
Thanks for listening to another episode of For the Wild podcast. I'm audio producer Andrew Storrs. The music you heard today was by Jonathan Yantz, the County Line Bandits, and Dimples. I'd like to thank our host and founder, Ayana Young, as well as the rest of our podcast team, Aidan McCrae, Hannah Wilton, Francesca Glassbell, Carter Lou McElroy, Erica Eckram, Aaron Wise, and Melanie Younger.
If you enjoyed today's conversation, please rate us on iTunes or wherever else you get your podcast. If you'd like to stay up to date with our projects and offerings, subscribe to our newsletter by visiting forthewild.world/subscribe.